over to the NCVLI team.
Wonderful. Thank you. Going to make sure that everyone from our team can get their cameras on as I get the other PowerPoint shared. Just confirming that folks can see the correct PowerPoint. Susie, is it still not is it showing?
It's on.
Great, thank you. Well, good morning, good afternoon, everyone. Excited to be here. My name is Meg Garvin. She, her are my pronouns, and I'm the executive director of the National Crime Victim Law Institute. And we are such privileged partners to get to be with NOVA on this effort to increase access to justice for military-connected victims. There's a long history of partnership between the National Crime Victim Law Institute and NOVA around this space, with NCVLI being kind of the lawyer side of the equation and NOVA having more expertise on the advocate side. And over the years, we have just continued to remind ourselves that we can't serve survivors without both advocates and attorneys. And so we're really grateful for the partnership in this Advocating for Military Connected Survivors project, and excited that we get to have this training, which is really lawyer focused, but we're also really grateful to have the advocates on the line with us as we move into this space, because you help us serve survivors and make us better lawyers. So be sure to ask questions. If we go too far into legal, for the lawyers on the line, ask a question and either we will be able to answer it in the Q&A module or we'll follow up. I do want to invite each of our amazing presenters to introduce themselves a bit, and then I will give a lay of the land. So I'm going to go left to right on the screen and have Ruth introduce herself, then Ryan, then Susie.
Hi, thank you so much, Megan. It's just so great to be a part of this presentation. NCVLI, NOVA, you all do such great work. Well, my experience is that I was in the inaugural Special Victims Counsel course for the Army, and I served as the National Guard Special Victims Counsel Deputy Program Manager, as well as a Senior Regional Special Victims Counsel and a Regional Victims Counsel. So I am just excited to be able to talk to you all about the work that we're going to be the work that hopefully you all will become able to become a part of. And yeah, I'm looking forward to the discussion. Thank you.
I guess it's my turn. Hi, everyone. Ryan Giles from Arnold and Porter. I'm counsel and lead our firm's pro bono efforts in representing military-connected sexual assault survivors, both in the military justice system and occasionally in civilian courts as well. My pronouns are he, him, so look forward to the discussion today.
Hi, everyone. I'm Susie Cowan. I am on the legal team at NCVLI. One of the things that I work on the most at NCVLI is this project, Advocating for Military Connected Survivors. And I've been working over the last few years on creating and helping manage a lot of the resources that we're going to talk about at the end, a lot of which were created with sort of this presentation and this group of attorneys in mind, and helping get everyone ready to sort of expand the pool of attorneys who can, civilian attorneys who can help military connected survivors. So really excited for today. Thanks.
Great. So as I give a little bit more about NCVLI, I know that we already had you introduce yourselves a little bit in the chat, but I'm going to do some more right now, which is either using your virtual hand raise or physical hand raise for those of you who are on video, or put in the chat, how many of you are advocates? Let's see how many advocates we have. Okay. Great. Those of you who used the virtual, go ahead and put your hand down. I see people coming in both spaces. And how many of you are lawyers? Let's see that also. Okay. Great. So we have a split, which is, again, fantastic. I want to tell you a little bit about NCVLI. You can put your virtual hands down if that's the way you identified right there. So the National Crime Victim Law Institute, or NCVLI, as I already shared, has partnered with NOVA on a number of projects, but most concretely in the recent years on this military project. We are based in Portland, Oregon at Lewis and Clark Law School, and our mission is to provide crime victim-centered legal advocacy, education, and resource sharing. And this training that we're doing today with Nova will hit each of those. On the legal advocacy side, we're going to talk about the how-to. Ruth has internal military legal experience. Ryan is a civilian lawyer providing legal expertise and representation. So we have two sides of expertise to teach us the how-to of legal advocacy today. We have obviously this training itself is the education, and then we are going to share a lot of resources because one of NCVLI's commitments is that no one should have to serve a survivor alone. So when you're doing the hard work of serving a survivor, we're your backstop, as is Nova. We have pre-written materials. We have how-to video guides. We have online resources that you can access 24/7. And then we have technical assistance that you can get one of us kind of walking with you as you serve. So that's what we're going to cover today. And then more specifically, what are we going to cover? What is our goal for today? We're going to try to achieve these 4 things. One, we're going to articulate key avenues of accountability in military systems with an emphasis on the court-martial process. I want to just pause on that. There are a lot of avenues of accountability for victimization that happens, that is perpetrated in the military. Administrative separation processes, other processes. We're going to focus on the court-martial process. And hopefully at another time, we can do a training on some of those other avenues. But they might sneak in a little bit. But again, just know we're going to focus on court-martial. We are going to identify key victims' rights afforded to military-connected survivors, especially those under Article 6B and under the military rules of evidence. And if you are already like, I don't know what 6B is, hang in there. We're going to tell you about it. I also am going to pause right here. In this learning objective right here, you see us using both the word victim and survivor in the same sentence. That's with intention. Victim is a legal term of art, and we use it anytime we are talking about rights, because rights attach to a person who meets the legal definition of victim. Survivor for many folks is a more empowering term, right? And so we'll choose that word if someone tells us that's what they want, but when we're in court, when we're talking about the law, we use victim. And more often than not, we just use a human being's name when we do things. So just wanted to pause on that. The third objective, we want to explain the role of civilian victims counsel in the military criminal justice system. What is it? Why does it exist? How do you do the work? Because our hope is that we are inviting those of you who are civilian lawyers into that space that you can represent a victim as they navigate military justice. And then we're going to recognize opportunities and resources available for those of you who do raise your hand and say, I want to be a pro bono attorney representing military connected victims. So we're going to share all of that with you. So let's jump in with one last administrative moment. The administrative moment, we have 3 hours together. We will take a break every 50 to 60 minutes. So that's 50 or 60 minutes. Hold on one moment. Sorry about that, everyone. You're meeting my big dogs through their barking. So every 50 or 60 minutes, you will get a break. We will, right before we go into break, that's when we're going to go into the Q&A module and look at all the questions that have been submitted so far and see which ones we should address right then versus holding. So don't wait to type your answer or your question. Type an answer too, but don't wait to type your question into the Q&A module. Put them in there as we go, and then we're going to collate them a couple of times during the training and get to them. Okay? All right. So let's jump in. My job right now is to give us all a foundation before I turn it over to Ruth and Ryan for their expertise. So I'm going to give you just a very basic foundational level setting for all of us. So a little bit of history on victims' rights. And I'm going to start on the civilian side and then go to the military side. So there is a long tradition before the 1970s on what is the role of victims in the US criminal legal system. I'm starting this timeline in the 1970s for us to consolidate it. NCVLI is happy to do more beyond that with any of you who are interested, but let's start in the 1970s. So right then, in the 1970s, the victims' rights movement, kind of the modern movement, was born or came into being. And it came into being in large part because there was a recognition that victims' formal legal role in our criminal justice system had been eroded. They had, by the 1970s, victims in our system, the civilian system, had started to be merely evidence. They had an evidentiary role in the system, but nothing else. That was a change from prior history, but that's where we were in the 1970s. And there's lots of support for what that looked like, from the federal rules of evidence to US Supreme Court case law. We don't need to go into it. What happened in the community was recognition that that was causing harm to individual victims, harm to our communities, and harm to the justice system itself. And that recognition brought together a whole lot of stakeholders, from the violence against women community to the law and order community to the civil rights community, to say, how do we put in place some pieces of law to correct the harms of the erasure of victims, right? The erasing of victims from the system as independent participants. And that led to the 1980s and 90s, when every state in the country passed laws, and the federal government passed laws to put in place rights for victims. The states passed both statutes and constitutional amendments. At the federal level, we had some of our initial statutory provisions being drafted and put into place. Those in the 80s and 90s were celebrated, and they should have been. And what we observed was they weren't changing culture, right? The law, is just words on paper until you can do something with them. And what was being discovered about many of the rights that were passed into statute and constitutional amendment in the 80s and 90s is they lacked clarity of enforcement. They lacked clarity of who has standing to ask for the rights and what happens if a right is violated. So that led to really the year 2004, when the Federal Crime Victims' Rights Act was passed. Now, that only governs victimization that happens in federal courts, right, or on federal land, not the military, not general civilian in states, right? But it became a model because it provided initially 8 rights. It's been expanded to provide more, but it also said very clearly, victims can assert the rights. If those rights are denied, they can seek appellate review. Something very different that can start to change the way we practice in our legal system. And then in 2005 through today, civilian jurisdictions across the country have started to look at the federal CVRA and say, let's move our law up to where the CVRA is. Now, what about the military system? So that's the civilian. What about the military, right? And with intention, the color on the screen, for those of you that can see colors, is purple. And purple is because it's for all branches. I'm just going to talk generally about all branches of the military here. In 2012, we were really fortunate, NCVLI was, to partner with the Air Force to develop and launch the first Special Victims Council program. So what was that about? Well, in the years leading up to that, if you just even Google, you'll see that the military was grappling with a lot of recognition of the amount of sexual and domestic violence happening across the branches that was coming to light. It's not that it was just starting to happen. It's that there was finally some light being shown on a problem. And so Congress, which has power over the military, started to turn its attention. And so different branches of the military, different leadership was starting to say, how do we respond? What do we do? And the Air Force said, well, let's launch the Special Victims Council program, which is an opportunity for every victim to have their own lawyer from time of incident forward, if they want it, to get some advice, counseling around what are your rights, legally, what is your position in all of this, and what would you like to do? And it started out with just sexual violence victims, but it has evolved. In 2013, we had a precedent-setting case of LRM versus Kastenberg, and by the fall of that same year, the Secretary of Defense said all branches should have lawyers for victims, particularly at this point in time for sexual violence victims. A few branches went beyond sexual assault right from the start, but most did not. In 2014, we had the National Defense Authorization Act, NDAA. You'll hear that mentioned a lot today, which passed Article 6B rights. And we're going to talk about that, but those are victims' rights. And then we've had regular updates to victims' rights since then. So why do we do this? Why do we need rights? Why do we need lawyers in the military system to provide? Well, I'm not going to give you a lot of data because I think based on who's here, we know a lot of this. But the Pentagon's own data shows that in FY fiscal year 21, nearly 36,000 service members experienced sexual violence. And I want to be clear, that wasn't just women. The data shows 19,200 women and more than 16,000 men experienced sexual violence in that fiscal year. In fiscal year 22, only 1 in 4 service members reported their sexual assault. So folks aren't accessing the justice system. Approximately 38% of female and 4% of male military personnel and veterans have experienced military sexual trauma. Domestic violence, stalking, all of these crimes are at what we deem epidemic rates, right? And so we need to get involved and serve victims. I'm not going to spend time on the definition of victim because we want to get to the how to do the work. But know that in your materials, there are legal definitions of victim, and that's who we are focused on today. And we really want to listen to our survivors. So we had a survivor share with us and Nova. What was it like having a lawyer? Why does having a lawyer matter? And she shared, when we went to court, there was an attorney representing me. Having someone there to explain to me, this is what a direct examination is. This is what a cross-examination is. This is what a redirect is and a recross. To have someone there to explain those things to you is just really an invaluable opportunity, right? And that's just one piece of why it matters what a victim's lawyer could do. So what are the rights? You can find victims' rights in the Constitution, the state's constitutions and statutes and rules, and in the federal statutes, rules, and case law. What do they say? On the federal side, the civilian side, the Federal Crime Victims' Rights Act provides these rights: to be treated with fairness and with respect for the victim's dignity and privacy, to reasonable, accurate, and timely notice, to be reasonably protected, to not be excluded, to confer, to be reasonably heard, to proceedings free from unreasonable delay, to full and timely restitution, to be informed of plea bargains or deferred prosecution agreements, and to be informed of these rights, an important addition that was added recently. There are similarities across systems about the rights, whether it's in the federal CVRA and we compare it to all of the states, or if we go to Article 6B, there are similarities. So Article 6B rights, again, this is the National Defense Authorization Act, NDAA, created 6B rights, and those are to be treated with fairness and respect for the dignity and privacy of the victim, to reasonable, accurate, and timely notice, to be reasonably protected, to not be excluded, to confer, to be reasonably heard, to proceedings free from unreasonable delay, and to restitution. Now, we've truncated the words a little bit, and there are differences, right? And we're going to talk about what they look like, but thematically, to level set us, generally speaking, there are similar rights across systems. So for those of you who are civilian lawyers or advocates, there's often going to be a similar hook, legal hook, to reach towards in the military to advocate for your clients in that space. Not identical, but similar, so that your expertise in your civilian space will serve you well in the military space. And then the rules of evidence provide us additional avenues, and they are quite similar to the civilian space. Rape shield law, psychotherapist patient privilege, and advocate privilege all exist in the military, and we're going to talk about those in our third hour predominantly when we do a hypothetical. We've already said this once, and Ruth actually gave her title, but there are lawyers in the military, right? They can be called Special Victims Counsel, Victims Legal Counsel, Victim Counsel. The words are different based on the branches, but they all serve survivors. But we need civilian lawyers too. And we need civilian lawyers for any number of reasons. One, sometimes a military victim doesn't want a military lawyer, right? There can be challenges with the differences in rank. There can be anxiousness about uniform. There can be, I just want someone outside the system to support me. And then in addition, there are constraints on where military lawyers can serve in terms of whether they can step into the civilian system at all. And they have limited scope of who they can serve. So there is a significant gap in the military for victims in need of lawyers to help protect their rights. And that's why we have Ruth and we have Ryan to tell us, how do we do it? Because we all want to serve, and they're going to share with us how we do it. So I think I'm going to turn this over to Ruth and Ryan together. I'm going to go off camera, but I am still here, Ruth and Ryan, to advance the slides when you want me to.
Great. Thanks, Meg.
Thank
All right,
you.
I think I will start. Why don't I, in terms of, by way of further introduction, for those of you who are civilians and wondering, to Meg's point, how can you get involved in these cases? Do you have to have had any prior military experience or background? Do you have to be knowledgeable about the military justice system? The answer to that question is no. And the reason I know that is because I didn't have any of those experiences when I started doing pro bono representation 12 years ago. My very first case was the representation of a midshipman who was allegedly assaulted by 4 members of the Navy football team. And I was asked to consult on the case given its high profile nature. The bravery of that survivor in that situation led to many of the changes that we're going to discuss today in the process and that Meg has already mentioned. I walked into court before there was an Article 6B. There were some evidentiary rules that existed at the time. And basically, I treated it just like I would treat any case. I learned the rules that apply in the jurisdiction. And I did that because there is a book, just like you would see a common federal rules of evidence or your state rules of evidence and all of the statutes and so forth. And we'll talk more about that. And I looked up those rules and I looked up the case law. And then I walked into court and I started to apply my law degree and my experience to be able to make the arguments to protect my client. And through the years, as I've gained more experience and knowledge in this space, I've learned the value that Civilian Victims Counsel can provide in this environment. And so as we talk today about whether and how you can help, I've had no more rewarding experience than the pro bono work in this space. I know the lawyers that work with me as well find this work to be extremely rewarding and important, and you're making a real difference in the life of survivors, which I'm sure, as I've seen in the chat, many of you already know and probably can tell me even more about. So let's talk a little bit about what the criminal justice system looks like in terms of reporting by a victim. And I'll start even before reporting. What is the jurisdiction of the military justice system? And the answer to that question is it is governed by the status of what is called the accused, the defendant, right? The person who's been alleged to have committed the crime. If they are active duty, wherever they are, whether that's in a civilian location, on a base, overseas, the military has jurisdiction over that individual. So it is not the victim's status that defines jurisdiction, but the accused status. When a victim reports a crime, when they decide that they want to report, there are different vehicles for doing so. Within the military justice system, if you are active duty, there is a clear set of procedures that allow a victim to report either restricted or unrestricted. There are some limitations. Sometimes reports become unrestricted involuntarily, but as a general rule, an individual who wants to report a crime can do so by working with the DoD's sexual assault response program to file a restricted report. A statement is taken, evidence is gathered, but the chain of command is not informed of the crime, and no charges are filed. This is often a helpful first step for survivors, especially early in a trauma, who are deciding whether or not they want to make that very personal decision to proceed formally with charges in the case. And there are some limitations on that. If individuals outside of the chain of command or become aware of it or report it separately, then the military investigative units, which we will discuss, will initiate an investigation and it will become unrestricted. If a military member reports through the military justice system in an unrestricted way, then that opens an investigation. And each of the military investigative units is required to investigate all reports of sexual assault. Many reports come through the civilian law enforcement system. This is typically when the victim is a civilian themselves, but it can also be reporting by those in active duty. For example, if they are outside of their base or they are in a location where the first report comes through a hospital, through a rape kit or the like, there can be civilian law enforcement as well. And that reporting creates two parallel systems for potential justice. We obviously have the military justice system, but as we'll discuss, if the offense occurs on civilian soil in the United States, then the relevant jurisdiction, the location, governs jurisdiction, and there is a potential parallel process for a civilian enforcement. They are separate sovereigns, the state and the federal government, when it comes to double jeopardy. So it is possible for a case to be pursued in both formats. Ruth, did you want to talk a little bit about reporting on the civilian side? I think you wanted to mention some stuff there.
Yes, yes. So from the National Guard perspective, which is Army and Air Force, there are two components. A lot of our cases, everybody thinks that the National Guard, or there's a perception that the National Guard is not a full-time force, and in many cases it's not. But in many cases we do have people who are active Guard reservists, and in the National Guard. Based upon my experience with the Special Victims Council program, there were about 43 to 48% of our cases have some kind of nexus or with the active component. And then in other with other situations, there are just maybe the status of the offender was a National Guard member, and the status of the victim was either a civilian or another military member. And in these cases, most of them are going to have some component to deal with civilian law enforcement. So as Ryan said, there could be parallel investigations, potentially parallel proceedings, and there could be actually a third one if the victim was or then the offender were ROTC students. So there could theoretically be a third investigation going on the campus. So going back to what, Ryan, you said about the status of the offender and the jurisdiction, in any of these cases, the very first thing that's important to know is whether the offender was an active duty member, whether the person was a National Guard member or reservist in a civilian status, and where the offense occurred. And the final example that I'll give about that is there's a base I was stationed in Alaska. There's a base called Fort Greely, Alaska. And it's on a federal, the status of the soldier is National Guard until they go into the bubble, and then they become active duty. So if an offense happens in the bubble, there's going to be different people investigating that offense than would be investigating outside of that offense. So that's civilian law enforcement, and it's important to know how they interact and knowing the status of the person who is committing the offense and the victim.
In terms of the investigations themselves, like who does investigations, right? So each of the branches has a military investigative unit, right? And you probably have heard of these. There is the Office of Special Investigations, that's the Air Force, NCIS, which is the Navy and Marine Corps, CID, which is the Army. These are largely civilian at this point investigators. There are some uniform investigators, but mostly they are federal law enforcement who have undertaken specialized training to investigate sexual assault cases. So they come with a greater level of experience and training than perhaps your regular reports and the civilian side, although I'm aware, of course, that in many larger jurisdictions, there are specialized units that handle sexual assault cases. So these are the law enforcement that provide the initial investigation. They will record the initial statement of the victim, for example. They will undertake the investigation of other potential outcry witnesses, others who may have been involved, and the like. And then they report their information up through and into the military justice system to actors that we'll discuss. Those are the cops, right? When you are in a foreign jurisdiction, it gets trickier, right? In terms of whether or not there is also parallel investigations happening on the civilian side, either in a foreign jurisdiction or here in the United States. And it is not unusual for there to be initial investigations on the civilian side that are then referred to the military justice system, especially in some of those denser communities where there are military bases, and it is not at all unusual for civilians to interface and interact with their military counterparts on a variety of criminal issues, including sexual assault. When a case happens, when there's a civilian, when the offense occurs in a civilian location, and then therefore there is a civilian authority that could be involved, a victim has a federal right to offer an opinion as to which jurisdiction they would like the case to proceed initially. Now, that doesn't mean that they have an absolute right to determine which location will take the case, but it does mean that they have a right to be heard. Frequently, when that happens, I will be asked the question whether or not I believe it's better for a particular victim to proceed in the civilian justice system and the military justice system initially. My answer to that question, of course, is it depends. We're lawyers, right? So we have to say it depends. I will say, and it may be surprising, that for the most part, I advocate for victims to participate in the military justice system. It's not 100% certain, but I'll give you some of the reasons why so that you can think through these issues as you're evaluating. It is, in my experience, more likely for a case to go to trial in the military justice system than in the civilian justice system. Now, that may be changing, and we'll talk a little bit about that here in a second, but it is more likely, if that's the objective of your client, to proceed with criminal charges and a trial, it is more likely to occur in the military justice system. What's the reason for that? I think there's a variety of reasons. I think the reality is that the military justice system has a view that it is willing to proceed with this is not uniform, but has in the past been willing to proceed with cases when there's not absolute certainty of a conviction. They're still applying an analysis as to whether or not the evidence can maintain, sustain and maintain a conviction, right? They have to undertake that analysis, and they do so. So it isn't that they just take any case, but as you may all know, these cases are hard to prove, right? And because of that, the standard for civilian jurisdictions, especially jurisdictions that are overwhelmed and have resource allocation issues, they simply can't prosecute all of their crimes, let alone all of their sexual assault cases. So they are far less likely to take action. In addition, in my experience, the military justice system currently has the most robust and entrenched victims' rights in the country. I practice in the District of Columbia, which means that my jurisdiction falls under the CVRA. We have rights. There's no question we have those rights, but the likelihood that the U.S. Attorney's Office is going to proceed with those cases is far less likely, and the rights are therefore not as meaningful. In many other jurisdictions, the rights that we're going to discuss today may exist in some esoteric way, but there's a lack of standing or a lack of clarity about being heard. And candidly, there are not many victims' rights organizations that appear in those jurisdictions. Now, there are exceptions. I think I saw some folks from Maryland, for example, where there are some robust representations that take place in courtrooms where judges are going to be familiar potentially and know what a victims' rights lawyer is. But in the military justice system, all courts currently understand the role of victims counsel. They may not agree with it. You may lose, but your presence will not be a surprise. Now, your presence as a civilian may surprise them because there are not that many civilian representations. And this is part of why we're doing this training, is because we want to increase that number for reasons that we'll discuss. But the courts themselves are familiar with the rights and the procedures that are in place, and they're also very willing to well, willing may not be the right word, but they understand that as a court they must listen to and hear from victims. So let's talk a little bit at a high level about the military justice system and how it works. We're going to go through this in greater detail later, and then we're going to have a hypothetical, as Meg mentioned, but just at a very high level, what does the military justice system look like? So there's a report, as we discussed, right? However that report comes in. Let's say it's a military investigative unit. We'll go with the Army. CID does an investigation, and they make a recommendation as to whether or not to proceed to trial. That recommendation is currently reviewed by what's called the Office of Special Trial Counsel. So this requires us to pause for a second and just talk a little bit about the changes in the law recently in terms of who is the decision maker regarding sexual assault cases. Prior to last year, the final decision maker as to whether or not a case would go to trial was what was called the convening authority. The convening authority was the officer within the chain of command of the accused. So generally it's going to be an 05 or an 06 who manages and has responsibility for that accused unit. It's very rarely is it the direct report. We're talking about full bird colonels, generals, and the like. That's generally the convening authority. So it's not usual that the offender may have likely knows or has heard of the convening authority, but they're not frequently the direct report. That decision-making process came with recommendations from lawyers, because we're talking about generals and admirals who are not lawyers typically, right? These are individuals who are in charge of wings or brigades. So they are not the individuals, they are not legally trained. And as a result of that, there was a significant pushback by many who monitor and track and advocate in this system that they were not the right decision maker, that it undermines confidence in the process, that you're essentially reporting to your employer and asking your employer to make a decision and not applying the independent determination that you have on the civilian side when you have a Commonwealth's attorney or a district attorney who is making those initial decisions on whether or not to charge a case. So last year that changed, and the Office of Special Trial Counsel was stood up. This is a separate unit that does not report into the chain of command of any of the other active duty units, that has responsibility for making an initial decision on whether or not to bring charges. Okay, that initial decision to bring charges is called a preferral. And there you will see there's referral and preferral. So the easiest way to remember this is that P comes before R. So preferral is essentially the charging behavior. It's the charges are are filed and the charges are served on the accused. And that triggers the initiation of a military justice process. It doesn't trigger a court, but it triggers the beginning of that process. Once a case is preferred, once charges are filed and the individual is informed, that initiates what is called an Article 32 hearing. It's essentially a preliminary hearing to determine whether or not there is probable cause for an offense that is governed by the Uniform Code of Military Justice over which that branch has jurisdiction. It is a process that's evolved over time. I mentioned my very first client was a victim from the Naval Academy. She was cross-examined for 4 days on the stand regarding the facts of her assault and being required to disclose intimate details around her sexual history information. A procedure that doesn't really exist in any civilian jurisdiction. And it was extremely traumatizing for her. And because it was a high-profile case, it was something that gained a lot of attention when reported in the press. As a result of that attention, the bravery of that survivor and advocates like some of the folks that are in this meeting, the rules for the Article 32 process were changed. And now it is largely a paper process. There is a hearing that is not even often in a courtroom, that is handled by someone called a preliminary hearing officer. They're not a judge. They could be a judge. There have cases where high-profile cases where the preliminary hearing officer was a judge. But generally, they are a staff judge advocate, an attorney, who is making a recommendation as to whether or not there is probable cause. And that on the paper transmission is essentially providing the recording of the victim's statement, any other information that the government wants to provide. It is not supposed to be a forum for discovery, and victims have a right to refuse to testify at that proceeding if they so choose. So they are largely an hour long, 45 minutes long, and after which the preliminary hearing officer makes a written recommendation currently to what's called the referral authority, the Office of Special Trial Counsel. So it used to go to the convening authority. Now, in most cases, it's going to this referral authority. And that recommendation is essentially whether or not there's probable cause and how the case should be disposed of, meaning whether it should go to a courts-martial or whether it should be handled administratively. That recommendation is non-binding on the decision maker. Here, again, we'll talk about the referral authority. Once and an Article 32 can also be waived, and it's not uncommon for an Article 32 to be waived by the accused. It then moves to the process of determining whether or not to refer the case. So regardless of the recommendation, the referral authority will determine whether or not they want to actually refer the case. And the reason it was called the convening authority was because there are, generally speaking, no standing courts in the military. You cannot just simply go to the courtroom, say at Edwards or Fort Cavazos or wherever, and there's a court there and you can go in there and file things and so forth. It has to actually be convened. When that happens, when the referral authority makes that decision, a military judge is assigned to the case. There are circuits within each of the branches, and there are judges within each of those circuits, and a judge is assigned to that case, which then kicks off the courts-martial process, the development of a trial management order, which I will discuss, and then the courts-martial itself. Once that happens, you are essentially in what would seem familiar to anyone who has represented a survivor in the criminal justice system. There are hearing dates, there are filing dates, there is a trial date, there are required discovery obligations, and the like. And so you're proceeding through the trial, and then the trial itself is largely similar to, there are definitely some nuances which we'll discuss, but it should look familiar. It's the same, it's the same Constitution with some limited exceptions. It's the same general rules of evidence with some differences that we'll discuss. Same basic concept of direct and cross-examination, same burden of proof, same general concept of a jury, although there are some differences there that we can discuss. So it proceeds as a trial. And then if there's a conviction, of course, sentencing, which we will also go over as well. And then finally, following a conviction, there is an appellate court process. And the appellate courts in the military we'll go over in some detail, because it can be confusing in terms of how cases proceed through the appellate court system, but we'll talk about that as well. Ruth, what did I miss?
You know what? That is a very good overview of the entire process. So I think you have gotten that. I'm going to be talking more about some of the underlyings that go underneath of these things. So yes, you did a very good job on
Great.
that.
Meg, do you want to go to the next slide unless you have anything you wanted to add? Great. Okay, so in terms of military reporting options, we talked about this, right? In terms of restricted report versus unrestricted report. At the end of the day, the most common thing that happens when somebody goes in to report through the military justice system is they sit down for an interview, all right? That interview is generally recorded. So you'll have two agents and the survivor. Ideally, you will be there representing the survivor as well. Many of my cases, however, I get later in the process. I am not there because they are not as unfortunately, many survivors are not aware of civilian options. And so they wind up either reporting without a victim's counsel, or if they're military, they will have their victim's counsel with them, which is a critical part of the component. Those interviews are the initial statement of the survivor, right? And they will create the case, initiate the case, and cause the agents to open a file and then continue on with the investigation. If a report is unrestricted, as I mentioned before, none of those things beyond the initial statement will happen. So the initial statement is taken and the unrestricted reporting is then sealed, and it's up to the victim to decide, absent some extenuating circumstances, on whether or not to unrestrict. They can certainly do so, and when they do so, the case is then initiated and the steps that I described will take place. There are different ways in which the military might be able to report. It's not just that you have to pick the right SAPR office, but especially those who are within the military receive regular and extensive what's called SAPR training. And frequently when you go into barracks or on bases, you will see a lot of information provided in terms of ways in which victims can report. There is something called, for example, a uniform victim advocate who is specially trained, but operates within that unit, has other responsibilities, but it is a protected, a privileged opportunity to be able to consult and provide information and resources. And then there are various SAPR offices around the country at the various military bases that are housed by victims advocates who are critical to that essential intake process. So when I say the first step in the investigation is the military, it is frequently not the first time a victim has told their story, because they will have communicated some of that information to SAPR as part of the initial intake process. Meg, you want to go to the next?
I think we're actually going to take our break right now. Ruth and I were just having a side chat. So let's go to the slide that's about the break, because we're at the 52-minute mark. And so we're going to take an 8-minute break, everybody, and come back at 30 minutes after the hour. And Ruth's going to talk a little bit about the culture for us.
Great.
All right, everyone, welcome back. Okay. So we just had our first level setting. We learned a lot of law. We learned some foundational pieces. In this second hour, we're going to start with culture, a little bit about military culture. Then we're going to dig back into the law. And then we're going to end this hour again with a little bit of what do you need to know culturally, a little bit around the military. So Ruth, I'm going to turn it over to you.
Oh, thank you, Meg, and thank you, everybody. So Ryan, in the last bit, talked a lot about the processes, the actual, what is going to happen from start to finish. And Ryan, you did a great job on that, by the way. Well, in the midst of all of that, there are a lot of things that are going on where an attorney can impact the processes and outcomes depending on what the victim survivor wants to see happen in that case. And I just have to take a moment and say, Not every victim survivor wants their case to go to court-martial. They may not want to participate because for a number of reasons. Number one, usually it's somebody they know. Number two, it's a process that is not overnight. Sometimes they just want to go and get on with their life. So I feel compelled to talk about that a little bit because it's you that has to be your representation is going to be based upon what the preferences of your client are, and that can change throughout the process. So, military culture. So, I'm just going to tell you a personal story. Is that when I came into the military, I was, let's see, 30 years old. I had two children. I didn't know anything about the military. I was a civilian one day. I went and got sworn in the North Carolina National Guard. And the next day, I was a first lieutenant. So when I went to get my uniform that week, I had another officer because I didn't know how to, I didn't know how to wear the uniform. I went to Fort Liberty, formerly Fort Bragg, and I went into the clothing and sales and I put on a uniform. When I came out and I was walking through the parking lot, I'll never forget, people started saluting me and they started calling me ma'am. And I was like, well, gosh, I wish my kids would call me ma'am, but now everybody around me is calling me ma'am. So that I tell that story because there's things that you just might not know with regard to how things are different in the military. And so some of the things that you need to know, I think one of the most important thing is there's a rank structure in the military. And in the military, rank is it's very, very important. And a lot of the times you're going to have a survivor who is lower ranking, who has been assaulted by somebody who is higher ranking, and then are thrown into a system where they are having to communicate with people who are higher ranking and they don't have a voice and they don't feel empowered. So with that said, it's to be able to understand what the rank structure is and knowing who you're going to be communicating with is very important. Another thing that's very important is the uniform. I mentioned this when proper wear and courtesies and other things that have to do with the uniform. When you put on your uniform, there are rules in the military. You can wear it in certain places, and in certain places you can't. And there's a way that you're supposed to wear the uniform. So hypothetically, if you were a military member and you were in a civilian court, say defending a domestic violence protective order, and your client is in the civilian court and says, oh my goodness, they didn't extend the order. At that point, the client victim is going to feel just not feel very good. They're going to feel like demoralized. They're like, why did I do this? Why did I participate in the process? I just want to quit. But then you get as a counsel, you say, well, tell me what happened. And your client says, hypothetically, that he came and he testified in uniform, and his friend testified in uniform, and he was driving. I went out and he was driving the government car, and that's when understanding the importance of the uniform. That in that particular example, you as an attorney would be able to say, wow, I don't think that they were supposed to be wearing their uniform. I don't think that they were supposed to be driving that government vehicle. Well, the civilian world doesn't care about that. But if you have a court martial going on, and that is something that the military does care about, which goes directly to a truth, veracity, and all of those things that matter in a trial. So the uniform, common courtesies, very important to understand about the military. The third thing that I think is important to understand about military culture is that crimes in what is considered a crime in the civilian world. Let me flip that. What might be considered a crime in the military may not be a crime in the civilian world. So if you, as a counsel, get a case for sexual harassment was recently made a crime in the military under the Uniform Code of Military Justice. There are also other crimes like conduct unbecoming. So just because there is not a court-martial may not be a court-martial on the sexual assault, there may be other avenues to pursue justice when, based upon other crimes. So the things that are important, I think, rank structure, uniforms and courtesies, and crimes, the differences in crime. So, and I'll just go ahead and just who and what is and who and what should be. When you're looking at whatever part of the process you're in, whether you're at the investigation, whether you are at the actual court-martial referral, you need to know who should and should not be engaged in the process and who is involved in the military process. And by understanding these three things, and there are a lot more, but these were my top three, that can help you be effective in advocating for somebody who doesn't have necessarily the voice to advocate for themselves. Now, I'll go down just something to say about administrative separations, and we can't go a deep dive in that, but that is, in the military, it's something unique, and it is an avenue that a lot of survivors will choose just because it's not necessarily as grueling, at least on the active side. So Ryan, do you have anything to add? Anything on that?
Yeah, let me just, thanks. That's helpful, Ruth. I appreciate it. So I think in terms of ADCEPs, Ruth is absolutely right. This is beyond the scope of this discussion, but I would put a pin in it, as Ruth mentioned, because it's an important part of the process. And essentially what it is there are various opportunities for what you would consider an employment action, right? The military can separate somebody because of their behavior without charging them with a crime. And to Ruth's point, many survivors who come forward and want to report do so for two reasons. I mean, there are many reasons, and every survivor's decision is unique to that survivor. But in my experience, survivors come forward primarily because they don't want anyone else to be harmed, and because they do not believe the individual should have the honor of wearing our country's uniform, right? And so an ADCEP process doesn't necessarily accomplish those missions completely, but it does provide an avenue and opportunity for the military to take administrative action, including reduction in rank and characterization of service. So a general discharge and other than honorable. There are limitations as to what can be done in those proceedings, obviously, because they are not criminal in nature. But there are some punitive actions that can also be taken, taking away pay, restriction to duty, restriction on duty, location, things along those lines. So if you get a case or you're involved in a case in which ADCEPs or Article 15 discharge is an issue, that's where asking the questions of the trial counsel, the prosecutors who are called trial counsel, and the staff judge advocates who are involved in that process will be very valuable for you and for your client, because you together can learn that process, and then you can identify the appropriate regulations that govern that behavior and represent them through that process as well. So just wanted to put a pin in it. If you get to that point, it's certainly, there's additional work to be done and additional information to know. And you do have a role as victims counsel in that process.
Yes, and the rules of evidence don't apply in those proceedings, and there's a lot that can be said and a lot of impact that can be made with civilian counsel in those. So,
Yeah.
thank you.
All right, so we're going to talk a little bit about the military rules of evidence. So this is the manual for courts-martial. This is the old one because the new one is in my luggage upstairs from my recent trip to Joint Base Lewis McChord, and I haven't unpacked. But this is what it looks like as a general rule. There is a recent one that came out 2024. This is your go-to resource. Either purchase it if you're like me and cannot read things online that are more than 2 pages long. Get a copy of this. It's like 35 bucks, okay? This has 3 primary things in it, okay? It has articles, the punitive articles, right? So the articles are the charges, right? Those are the Article 120 offenses are the sexual offense category, and within there are various types of crimes, right? There is sexual assault without penetration, there's penetrative assault, there's abusive sexual contact, there's viewing images without a person's knowledge. There's a variety of charges within the articles, and that's really what needs to be proven by the government beyond a reasonable doubt. Not really, that is what needs to be proven by the government beyond a reasonable doubt. There's also the military rules of evidence. Many of those military rules of evidence are, like MRE 412, are drawn from the federal rules of evidence, but there are a lot of differences between the military rules and the federal rules because of the uniqueness of the military system. And so that can be somewhat daunting and challenging in the beginning. But the reality for me is it's no different than if I were practicing in the federal court in the Eastern District of New York or a state court in Southern Texas. There are unique rules in those jurisdictions, and your job as a lawyer is to learn those. And this is the place that you can go to do them. So when I first took my first case, I literally just started to read the rules and to understand their application and so forth. And so in addition to the military rules of evidence, there is something called the rules for court-martial. These are the processes that govern trial. I recommend reading them as well. They're very accessible in terms of getting a sense of how trial works, how jury selection works, how you go through discovery, how the Article 32 process is conducted. So that is your best resource for really trying to understand the uniqueness of the procedures themselves. There's several rules that are of importance to a survivor, right? In terms of their direct rights, the rights that exist under Article 6B that we will talk about. And they are here. Military Rule of Evidence 412, which is the rape shield law, which is modeled on the federal system. This is a common area of practice for lawyers in the military justice system. Victims have a right to be heard through counsel in order to advocate for their rights under Military Rule of Evidence 412. And so what do we mean by that at a high level? At a high level, propensity evidence and evidence of sexual history is inadmissible in a court-martial unless it falls within an exception, all right? And we can go through this in more detail if time permits, but at a very high level, what happens is the victim is provided notice, typically by the defense, that there is 412 evidence that will be potentially introduced at trial. When that happens, it triggers a briefing schedule where the defense has the burden of proving why the evidence, if governed by 412, if it is propensity or sexual history information, should be admissible in the court itself. It is a tool to protect the dignity and privacy of the victim, and also to keep out extraneous information that feeds rape culture myths, and is not relevant to the proceedings themselves. So it is very common as part of the process for this information to come up, and particularly when there is a prior physical intimacy, a relationship between the accused and the survivor. When that happens, it is frequent that 412 evidence will be evaluated and the court will rule as to whether or not it's been admitted. The government also has a position with respect to 412. So part of the job of the lawyer here is not just to argue in court, but to advocate for your client to the government on behalf of your client. Military Rule of Evidence 513 does not exist in the federal system, but it is a recitation of common law, the common law protections of the psychotherapy patient privilege. In the military members do not have the same medical privacy rights as civilians. When you join, you give up some of those rights. So there is no medical privacy privilege in the military for records that are housed in military institutions. There are some things that you can do to help protect those records, and they're not automatically turned over. And we can talk about that if folks have questions. But psychotherapy patient privilege does exist. It has exceptions. When I first started to represent survivors, military rule of evidence was 513 was different, but it was also something that was routinely turned over to courts. It did not have as many of the procedural protections that are in place now. Essentially, every court was provided those records, reviewed them in camera to see if there was anything that the court thought that they should provide to the defense. That no longer happens for pure psychotherapy communications. What I mean by that is not diagnosis and treatment. There is an unfortunate, in my opinion, recent case that was handled down by the Court of Appeals of the Armed Forces that held that diagnosis and treatment does not fall within the protection of the psychotherapy patient privilege, only communications. But unless those communications are waived, they are not routinely turned over, and it's a rare circumstance that defense is going to be able to meet the high standard for turning that information over to the defense. But it is something that routinely comes up as well. Defense counsel routinely seeks, and you'll need to advocate for your client in that space. Military Rule of Evidence 514 creates an important victim advocate privilege. I have cases now, for example, in which there is a DoD victim advocate who is assisting my clients, and we work collaboratively together. And in that environment, the victim advocate is able to provide services and support, and to do so in a way that's informed because they know what the process is. So my practice is when there is a positive relationship between a victim advocate and a survivor who is my client, I encourage that to happen and try to inform that victim advocate to the greatest extent possible about what's happening so that they can better do their job and they can help me be a better lawyer. So that's where we are on the military rules of evidence. I don't know, Meg, sorry to say this out loud. I don't know if we're pausing for questions, if I should invite questions, but I'll leave it to you to tell us.
I love both, right? So some folks are starting to put questions in. And one question just came in and in the chat because they cannot access the Q&A section. So the timing is beautiful. The question is, were you just referencing is this Millett materials 513? Is that what you were just discussing?
Yes. So Millett is a decision by the Court of Appeals of the Armed Forces. And so if you go to the Military Rule of Evidence 513 as it currently exists, it defines the scope of the privilege based upon communications. And essentially what the Court of Appeals in Millett said is that privileges should be narrowly construed so that they give accused the greatest protections and access to information, which is a general goal of our criminal justice system, is to give defendants access to information in order to be able to effectively defend themselves. Privileges should be narrowly construed, and this privilege talks about communications, and their view was diagnosis and treatment is not a communication. It's a medical condition. And there is not a medical privilege, so that information is not protected. It does not mean that it's automatically turned over. So this is a bit of a sidebar, but an important point. I saw that there was someone from Tacoma in our group here. I was in Tacoma earlier this week with my updated rules of evidence, and I was arguing a diagnosis and treatment issue before the court there, and I was arguing it under the discovery rules. What was the discovery standard that must be met? Is it relevant and necessary to the matter? And so I was making arguments around materials that were not necessarily protected by the privilege, but that I didn't believe should be turned over because the survivor has Article 6B rights and has a right to be heard when their confidential personal information is being subpoenaed. And so those are important rights that exist beyond the privilege itself in the medical, especially with respect to medical records and other personal private information.
Awesome. I think that was the only question right now. Some are being answered directly. I will also flag as we move on to this next piece that Ryan, I think you're starting us off on. What Ryan just did for all of us is remind us not to be narrow in our thinking, right? Just because there's a rule, that doesn't mean that is the whole discussion. So as you're advocating, particularly around privacy, look beyond that. Susie, was there another question you wanted to put in? I see you came on.
I did not do that on purpose. So, you know,
Brilliant. All right. All right. Well, what can we expect at a court martial? Let's turn to that.
Sure. So this is an example of a trial management order. I discussed before, we have the preferral of the charges, which is an initial charging instrument that's served on the accused that initiates the Article 32 process. Following the P for preferral, we move on to referral, right? When a referral happens, a military court is appointed, and the military court works with the parties and the victim. Theoretically, that's what's supposed to happen. The victim's also supposed to be consulted around trial availability dates. And flowing from that and the court's own calendar, you get a trial management order. And this is an example of what a trial management order looks like. So let's talk a little bit about timing in terms of expectation setting for your clients. It continues to be the case that it takes an inordinately long period of time for these cases to be investigated. It is not uncommon for investigations to take over 6 months and sometimes over a year before the investigation is complete. That is a point of contention with the various military investigative units. It's an area of focus that Congress has identified them being more efficient in this space. Obviously, it's in everyone's best interest that there be an efficient and comprehensive investigation. They are just candidly taking too long. However, once a case is initiated, absent some unusual circumstances, it usually takes about 1 to 2 months for the case to go from that initial preferral to a referral, to where you then get an order. So 1 to 2 months typically. Now, obviously, there are outliers. Multi-victim cases can take longer. Cases that are overseas in terms of access to discovery can take longer. But that's generally the time frame. In terms of from referral, right, so that now it's with a court, to trial, is typically somewhere in the 4 to 5 months range, which is, again, another reason why when you're talking to your clients about whether or not a civilian or military option is the jurisdiction they'd like to proceed with, the amount of time it's going to take to go to trial is important. In my experience, 4 to 5 months is an extremely short amount of time for a sexual assault case to go to trial in a civilian court. And so that creates a trial management order. This is what it looks like, right? So you've got your initial arraignment, right? Entry of plea, which can be waived or postponed. Initial discovery, as part of the initial discovery process, will take place. And here's where it's worth pausing to talk about discovery. One of the unique things in the military, sorry, let me take a glass. One of the unique things in the military is the discovery process. The government is actually the entity that's responsible for collecting all of the discovery in the case, not just what the government wants, not just what the government has in its possession, but also what the defense is seeking. So there's a set of routine disclosures that occur as part of the regular disclosure process. But if a defendant, for example, wants to see service records, wants information regarding potential witnesses, wants witnesses to be called to the courtroom, wants medical records to be provided, they ask the government to obtain that information. The government then has a choice, generally speaking, as to whether or not they provide that information. And that's an important point of communication with your clients. Though those discovery opportunities will undoubtedly impact your client, things like their phone, their computer, their medical records, as we've discussed, their medical board information if they're going through a medical board. That is information that defense counsel routinely seeks, and your client has skin in the game, right? It's the survivor's personal private information. So whether or not you're in court or you're advocating with the government, there are these moments in the court-martial process as it relates to discovery where your victim's rights are going to be implicated, and it will be important for you to stay in touch of and on top of what's happening on the discovery. That means that you should be communicating routinely with trial counsel, something that we'll discuss, in order to not be surprised by the discovery. There are then reciprocal disclosures, although there is not reciprocal discovery in the military defense discovery. There are some reciprocal disclosures, common notices like 404B, 412 you see here. There's specific timeframes for the 412 motions that we alluded to before. And then there's a response to motions, and then there's hearings. Here, the Article 39A is what they call a hearing. There's a specific process for having a hearing, and it's under Article 39A. And that is what it sounds like. That is a pretrial hearing for the court to determine whether any issues of dispute. And that could include discovery issues. So if the government decides it does not want to provide sought discovery from the defense, it will inform the defense, and the defense then files a motion with the court. Court then determines whether or not that information has to be turned over. There's also many other motions that get filed along the way. There are standard motions to dismiss because of things like suppression motions, for example, because somebody wasn't appropriately Mirandized. There are also motions that are unique to the military. There is a concept called unlawful command influence that exists in the military, and essentially the argument is that the decision maker, when it was the convening authority in particular, was unduly pressured or influenced in a way that would make moving forward with a prosecution fundamentally unfair. Those types of motions are unique to the military, but by and large, these are usually general criminal procedure motions of which your client may have direct rights or may just generally care about them because, of course, the entire case impacts them, right? It's their trauma, it's their assault. So whether the case is a Fourth Amendment case or seeking the survivor's medical records, they obviously have an interest in the entire proceeding. There's usually two of those, although there can be less and there can be more that are scheduled throughout the court-martial process. Just because they're not in a trial management order, though, doesn't mean one couldn't be scheduled. And it's important for you to stay connected with the prosecutors to make sure you're aware of when those dates are. Those are in-person hearings largely. During COVID, the courts were more willing to allow for remote arguments, and there is a procedure in place that permits it. I have seen a recent trend, at least in the Army, however, in which remote participation is discouraged. And so it is not uncommon for courts to reject those requests. Now, if you're a civilian like me and you're going to be crossing the country, you can certainly make the argument and request a remote hearing. I generally prefer to be in person for those hearings, if at all possible, but there is a possibility you can participate remotely in them as well. Finally, there's notices of pleas and there's jury instructions and the like, and then that leads to the trial itself, which we'll talk a little bit about when we get to our hypothetical.
Ryan, there are two questions, or Ryan and Ruth, whoever wants to ask this, that seem relevant right now. And the first one is, you talked about discovery and the difference between military and civilian with regard to the government. But the question is, can you explain how what Victims Counsel position is in relation to discovery, including such as getting access to the suspect's law enforcement interview?
Okay, sure. Yeah. So that's a great question. So here is the answer. Your ability to access the report of investigation or the investigation materials itself varies by branch and by prosecutor. All right. Every branch except for the Air Force withholds the report of investigation from Victims Counsel. All right. It is not routinely provided. I have had rare circumstances where it has been provided for a very specific reason, but it is extremely unusual for you to see that information unless you are a military detailed Air Force Victims Counsel. The Air Force has an open access system for those who are actually active duty. Now, importantly, they don't routinely provide that information to civilians. So if you're co-counseling a case, which we'll talk about, you may be able to get that information, but even that Victims Counsel may be restricted in sharing it with you. So the bottom line is, I rarely see, as part of the government affirmatively handing me the accused statement to police. Now, how do I learn of the information, and how do I learn about what's happening? When motions are filed, I will ask that all of the motions in the case be served on me. I will ask the government to do that. Prosecutors vary in whether or not they are willing to do so. The Army is the least likely to provide every filing in the case, and there is not a docketing system. So, I mean, there is a docket in the most general of sense that sort of lists dates for certain hearings, but there is no PACER system and no ability to access that through a docketing system. So the only way you're going to get that information is if you're served it by one of the parties or the government turns it over to you. I strongly recommend that you ask the government in every one of your cases to provide everything that's filed, because that's the only way that you can effectively advocate for your client. Whether the motion is one seeking information directly from the victim, or it's a motion to suppress a statement, it impacts the victim, right? So in that case I was mentioning to you in the Navy Yard, for example, I came in the case in the middle, so I didn't have all of the facts, and I wasn't provided with any of the filings in the case previously. And I went to a hearing and listened to what appeared to be an argument suppressing a statement. I didn't see any of the briefing, and I just heard the basic arguments in the court. And ultimately, the court suppressed that statement. I was not able to explain to my client what the arguments were, or to provide my opinion as to whether or not that judge's decision was consistent with the law, was an overreach, or was inevitable. I wasn't able to give her any of that information. And so as a result, she was less informed about the process, and it eroded the trust that she had. So I think I answered the question, Meg, but
You did. Thank
Okay.
you. And folks can ask an additional one. I did want to, before we move to the next slide, we have one other question pending that really relates to court-martial at the trial court level. And that is, if a crime happens in other countries, what is the communication with law enforcement there like? Because you talked about you can talk to the law enforcement. So what does that look like?
Yeah, I've only had a handful of cases that occur outside of the United States, and when I have, it has been extremely challenging. I have not been able to connect with the law enforcement.
Ruth, do you have any experience or guidance on that?
That's where we're talking about relationships. That's where, if you were involved in one of those cases, it would be beneficial to have a military special victims counsel or a victims counsel to be able to facilitate that, because the people who will have communication, the best communication with foreign governments and foreign entities, are going to be the military folks that are in the theater. So as a civilian, straight civilian, it's going to be very, very, very difficult.
So definitely those relationships matter. That's fantastic. I want to move us on. So we covered a little bit of the court-martial experience, meaning the trial court level, really, in many ways. And so what about appellate rights? What does it look like around victims' rights and their ability to seek appellate relief?
Sure. So, and Meg is really the expert in this, but I will do my best to channel my inner Meg here. The victim does have a right to petition the Court of Criminal Appeals for a writ of mandamus. Now, let's just talk about the court structure for a second. So, trial court, is the trial court, right? And then the immediate appellate court is the Court of Criminal Appeals for that branch. So there's a Navy Marine Court of Criminal Appeals, there's an Army Court of Criminal Appeals, and there's an Air Force, and there's a Coast Guard Court of Criminal Appeals. Each one is their own jurisdiction, okay? And so the law in that branch is what governs. So if there's a disagreement between branches as to the law, the court follows its own branch rather than a sister branch's rules. It is information, obviously, that can be persuasive authority when other branches, but it's that Court of Criminal Appeals that hears the writ. The writ has an exceedingly high standard for relief, something that policymakers have looked at, and the DAC IPAD has made recommendations to change, but it is an extremely high standard for relief. And when I talk about a writ, I'm talking about it's either pre-referral, which is very unusual, very, very unusual, or during the court-martial itself. So this is not after a conviction when I'm talking about appellate rights. This is the opportunity to seek exactly an interlocutory appeal. And that interlocutory appeal happens so that the victim's rights are not eroded, right? So if the victim is objecting to the production of, say, her therapy records, she can't wait until the court-martial is over. If those are provided, her right is lost. So the writ is an opportunity for the victim to get relief in the Court of Criminal Appeals on specified issues. And that includes the Article 6B rights that we talked about, right, which are parallel generally the Crime Victims' Rights Act. The Article 32 process, which is that pre-referral process that I talked about, which there are very rare, and specific military rules of evidence. But bottom line, thanks, Mike. Bottom line is make an argument, like whether it's within these rules, find a way to get it into Article 6B. There's a way to seek a writ. There is not a they're supposed to be handled expeditiously, but there is not a specified time frame for relief. So one of the challenges with respect to appellate rights, something I frequently confront, is a victim who has gone through this lengthy process, is on the verge of going to trial, finally getting their day in court, and an issue comes up which could potentially move or push the trial. And so every survivor has her or his rights that they want to enforce, and also the practical considerations around what would flow from a potential delay. So those are the things you would need to talk to your client about before you seek a writ. It's also just from a practice standpoint, you want to be ready to move pretty quickly, so that you can seek that writ quickly. You want to get an order from the court to make sure that the order has been memorialized so that you can appropriately frame it for the Court of Criminal Appeals. The ability to then appeal it to the next level, which is the Court of Appeals of the Armed Forces. So you've got the trial court, the Court of Criminal Appeals, and then you have the Court of Appeals of the Armed Forces. Court of Appeals of the Armed Forces is essentially the federal circuit for the military. The next court up is the United States Supreme Court. Okay. The Court of Appeals for the Armed Forces has rendered some decisions that make it extremely difficult for them to hear a case. There are some procedures in place that allow for certification of questions to the Court of Appeals, but it is extremely difficult and relies upon the staff judge advocate to essentially say to the Court of Appeals, you must take this case. And here's the issue that you need to render a decision on. So it's very limited. In terms of, for a victim, in terms of the actual conviction process, the victim does not have a right to participate directly in the appeal of a criminal conviction. There are lawyers in the various branches that do advise on appellate rights issues to keep victims informed about what's happening in that process. And there are potential opportunities to seek an amicus on specified issues. As a victim, you can try that. I haven't had a case like that in a long time, but that's a potential opportunity. But the victim is not a party under the military justice system standard, right? I'm not sure this is terribly different from the civilian world. So their opportunity to be heard at that appeal is going to be extremely limited.
I just want to, before we move on to the next slide, just really reiterate what Ryan just said about that CAF, which you may hear sometimes said, the Court of Appeals for the Armed Forces really has come out with some decisions severely constraining the ability to seek appellate review there. And I do think that is something that's being looked at from a policy level to ensure that there's further review. But we are where we are right now. So we've had this overview of the court-martial. We've had an overview of appellate rights. And we've started to touch on what does legal representation look like through the questions, but let's dig in a little bit more on the nitty gritty of what does representation of a military connected victim really look like?
Yeah. So let me start with representation agreements and let me sort of talk about what is helpful. I work at a big firm, right? So we have offices around the country. One of the great things about representing a victim in the military justice system is you can be barred anywhere. So the ability to enter your appearance, your ability to make arguments is not dependent upon where you are licensed, which is very helpful. So the initial step in a process for me, who receives most of my cases from a pro bono referral network, is representation agreements. And these are, for us, are our standard pro bono agreements in place. There are nuances that occur when you're representing minors, and there are nuances that occur when you may be representing more than one victim in a single prosecution, in a single courts-martial. So there are obviously some nuances, but memorializing that agreement and per your procedures is a helpful one. It's also necessary frequently when you get in a case like this to enter not just your appearance in court. So there's a standard notice of appearance that the trial counsel can help identify what needs to be said in each of the jurisdictions. And there are also, importantly, unique rules of court that exist within each of the military branches. So the Army has a universal one. My recollection is the Army has a universal one. Some of the other branches are circuit-specific rules, and you should read those because there are victim rights issues that are identified and laid out in those in terms of notices and so forth. So you've got the representation agreement in place. You've got your notice to the trial counsel, to the prosecutors, typically via email, about your representation. Notice to the military to ensure that the military does not speak to your client without your permission. And then eventually notice to the court itself through a formal notice process. In terms of interactions with the military, if you walk your client into an initial interview or a subsequent interview with an investigative unit, it's going to look like, if you've had this experience elsewhere, it's going to look very similar. There's not fundamentally much in the way of a difference other than the military investigative units expect to see victim advocates and special victims counsel or victims counsel present in those interviews, right? So there are some best practices that I could talk about in terms of walking your client into an initial interview, what you bring, what you don't bring, what you turn over, and the like. Bottom line is, I typically tell my clients to come prepared to share specific images of things that they want to share as part of the process, and we'll print those out, or we'll take screenshots of those individual things. We will not routinely turn over an individual's phone. You do not do that, at least as an initial step in the process, because the military does not have a way to segregate and identify only relevant information. When it takes a phone or it takes a computer, it pulls an entire image of that, generally speaking, of that device. And so we work to narrow and constrain those interactions. Once that initial interview takes place, it's occasionally you will talk to the investigators, but generally you're going to be talking to the prosecutor, the Office of Special Trial Counsel. There are offices with that across the branches and then across the regions who are responsible for assisting in the investigation and prosecution of these cases. They are specialized, trained prosecutors, and they're supposed to be extremely knowledgeable about the practice, at least at the higher levels, as the senior prosecutors, about prosecuting these cases. In my experience, your interactions are going to be much more frequently with the Office of Special Trial Counsel than they're going to be with those individual military investigative units after the initial statement is provided. Trial counsel, for example, will conduct subsequent interviews of your client. They typically do so without law enforcement's presence. They'll have a paralegal who takes notes and provides a summary to the defense. Obviously, the government doesn't represent your clients. That's why you need victims counsel, right? I'm telling this group something they already know, but that means they have Brady obligations you do not have, right? So just be mindful of that when you're engaging and working with special trial counsel, that you prepare your client for that, right? And that you make sure that your client understands a couple of things about that the government is going to turn those things over to the defense. And also, from my perspective, important to explain to the client why. Because many of my clients initially believe the government is on their side. And part of my job as victim counsel is to explain that the government is supposed to be on no one's side, which is why she or he needs a lawyer. That's why we do this work, right? So in terms of filings, this is what I talked about a little bit previously. So there is no docketing system. There are court rules that are sometimes followed in certain jurisdictions in terms of what needs to be in a brief and who needs to receive it. But filings in these cases are via email. You send them to the judge, you CC the parties, and maybe you CC a clerk, and that is how things are filed in the case. It is very common for there to be email interactions between the court and the parties, and sometimes you, regarding the status of the case, the status of motions, and then the actual service of those motions themselves. In terms of the access to those filings, as we discussed, that is something that you have a right to certain filings. You have a right to 412, 513, and typically what trial counsel is the one responsible for providing that information to you generally. When they do, they are the gatekeepers, and that's part of the problem. It's an issue we continue to face, and one that I've advocated in multiple fronts to anyone that will listen, that we need to change the system. But the reality is you'll need to be proactive to make sure you see what's been filed in the case, and then to get your things filed. So the one nice thing about it is it's easy to send an email. So in terms of actually getting your filings to the court and to the parties, it's a relatively straightforward process. In terms of your representation, so it depends on the scope. So when I represent a client, I'm almost exclusively doing it in the military. And part of that reason is because I lack competency on certain family law issues. I also am not licensed to practice in most of the jurisdictions in which these offenses have occurred. So I can't provide the kind of level of support that I would need to on the civilian side. So when that happens, that's when I call Meg and we try to find somebody on the civilian side within that jurisdiction who could potentially be of assistance to them. But that's not, there are opportunities for you to engage on the civilian side for sure. And there are definitely situations in which cases are proceeded initially in the military that are then charged in the civilian world. Or there are cases in which the civilian authority decides they want to prosecute the case. And they are not required to listen to the military, although that is rare. And then in terms of administrative boards, like I said before, that's a little bit outside the scope of what we would talk about today. But the point I would have you take away is there is a role for you to play in that space. Sometimes those victims testify. Sometimes those victims testify in person or remotely. They will be interfacing with the reporters, which is usually what the prosecuting authority is called when you have those administrative boards. So there are definitely roles for a victim in that space. The rights themselves are very amorphous and all over the place and inconsistent. So a lot of it is thinking outside of the box and making fairness and due process arguments for your client.
Yeah, and I'll go ahead and just, with the regard to law enforcement interactions and the military and civilian and court and the military and civilian, there could be some crossovers. And as a victim counsel and somebody who is on equal footing with the prosecutors, somebody who's a lawyer, somebody who can talk the talk, walk the walk, a lot of times you can have influences on processes to be able to get them to move faster or be able to slow things down. I'll give an example of a case in that, there was a civilian, a military member who was assaulted, and there was a safe kit that was done outside of in a local hospital, and there was a huge backlog of safe exams, so it was delaying the process, and the military couldn't do anything until the kit got back. So as a victims counsel, I worked with the Alaska State Trooper, and I also worked to petition the district attorney in that district I wasn't the primary, but I was there to be able to get the safe kit expedited. There was a process for that. So instead of taking 2-year backlog and a grant to get the 100,000 safe kits that were tested or have to wait on that, we were able to get the safe kit frontline. At that point, I was able to liaise with the prosecutor in that district to be able to say, hey, you want to, let's go. She wants to prosecute. She was raped when she was in basic training. She said this was never going to happen to her again. You all have got the kit, you've got the witnesses, you've got everything. And he said, well, and this client happened to have the person held at gunpoint. And the prosecutor said, well, if a jury might think that because she didn't shoot him that she wasn't raped, so I'm hesitant to take that case. So in the meantime, we were able to get an expert, Mila Nader. She was in The Invisible War. She was the CIA. It's a pretty famous military movie. We're able to get her. I was able to communicate with her to get her to be an expert witness at the grand jury. She came and testified. He was indicted. At the end of the day, when he was convicted of 30 years in prison in a civilian court, where I was able to advocate in an administrative separation for him when he fought the board from jail. Okay, so I'm sitting in the administrative hearing. So he was discharged he was discharged. Okay, sitting in jail, he was discharged. But I use that example because a lot of the things that might be happening on the civilian side, the military has to know what's going on to enable them to be able to do what they need to do in the process. So I went a little off on that, but I hope it was a helpful example about some of the things that you as civilian attorneys can have impact on.
It's actually a perfect bridge to our last component before we take a break in just a couple of minutes, which is you were right there getting back to building relationships. So let's do this last component piece before our final break. And when we come back from break, we're putting all the pieces together in a hypo. But what are some last pieces you each want to share about building relationships to aid representation before we go to break?
Well, I think in the military, you've got to know wherever you're going to be representing, whether that be in your own state. And I encourage you all to, if you're whatever state you're in, and if you're interested in this work, this is where you can use your local. You've got military. If you have a military installation, if you have a National Guard, you can get to know who the sexual assault response coordinators are, the victim advocates, the behavioral health specialist. The chaplain is a good person to know. Always know who in each case, who is the military commander in the case in which you're going to be involved with, because you may be communicating with the commander on behalf of your client. So also on the civilian side, key actors to know, I think, are wherever you're at, who, if there's a civilian organization, a sexual assault, domestic violence center, and I'm just looking right here. Just saw that. Hi, Debbie Tucker, from the Domestic Sexual Violence in Austin, Texas. You all do good work out there. But working together to understand if something comes in, then that person on the civilian side would be able to say, oh, I need to contact the military person, my counterpart on that side. And then you can start to form those relationships. So, and I think how to connect with these actors, I think it's challenging. I think that is one of the most challenging things that we do, because I know that there's trainings with military partnerships with civilian organizations and doing collaborations. And I think that's where we have the biggest challenges in being able to connect locally with local areas. I mean, I've got a civilian case, and I got it randomly from somebody that I knew, somebody who called me off the phone, and I'm in the area, and it's, so I think that's one of the biggest challenges. What do you think, Ryan? What do you think, Meg?
Yeah, so I think, so for me, key military actors to think about, just to identify them by title, and Ruth has mentioned a few of them, right? You start with the most obvious. It's going to be the military investigative unit agent that's involved in the case.
Yep, forgot that. Sorry.
No, it's all good. I'm just going to go sequentially, right? So that may very well be the first level of engagements. It's going to be those military investigative agents, and that could vary. They can change over time. They can move. There can be more than one. So getting to know them a little bit, and developing that relationship in a way in which you are facilitating them gathering the information. You're not serving as an impediment to the gathering of information while you're still protecting your client's rights. Okay. So that's one. There's the prosecutors in the case, the trial counsel, the Office of Special Trial Counsel. You're going to definitely want to develop those relationships. There's typically a senior prosecutor and a junior prosecutor, and then a paralegal. You're going to want to get to know them. You're going to want to set up routine check-in meetings. You're probably going to need to potentially confirm to them that you are not nefarious and that you know what you're doing, and as part of a way to facilitate that process. You may also be working alongside a military detailed victim counsel. It is, in my experience, the best type of representation is one in which both a military detailed and a civilian lawyer is representing the client. That's a co-counseling model that exists. There are sometimes procedures that are put in place to make sure that there's clarity as to role. So you sometimes will have those conversations. But my experience, especially when you start talking about on-base issues, access to the prosecutor, access to the files and the filings, just being present in the location where the crime is being prosecuted. All of those things can be beneficial on top of the expertise that these special victims counsel have with military procedure, especially on the administrative side. So Special Victims Counsel, thanks to Meg, go through a fairly rigorous training process. So getting to know them and having them as part of your team is definitely something that I would encourage. Now, as we discussed, not every victim is entitled to victim services, at least Special Victims Counsel services. So you may not have a choice but to proceed on your own, or the relationship may be so fractured that your client does not want there to be military detailed counsel. In addition to that, in addition to the prosecutors, I recommend getting to know the defense counsel, calling the defense counsel and introducing yourself, explaining their role. Having positive relationships with defense counsel despite an adverse relationship or potentially adverse relationship has its advantages. You can make that human connection. I've had cases where it's actually been the defense counsel who has sent me a scheduling order. So make sure that I was aware of what was happening. In part because he didn't want his own client to then have to go through that process twice because we didn't get the notice that we needed. It also frequently will come up in the question of plea agreements. The military currently takes victims' views not just theoretically into account, but meaningfully into account in terms of how they want to resolve cases. And so where a defense counsel wants to, for example, have an Article 15 in lieu of a court-martial, they will consult, they will want to know what the victim's opinion is on that. So having that interaction with them is obviously important. Interfacing with the court is obvious, right? You're doing that through the formalized process with the courts and in your filings and in your oral arguments and so forth. And then there's a couple of other folks that you should know. If you're the lawyer and not the victim advocate, then obviously knowing if there's a victim advocate in place can be important. I think it's also important for you to know an individual called the Victim Witness Liaison. So the Victim Witness Liaison works within the Office of Special Trial Counsel. They are not a victim advocate for your client. So they work for the government, but they are responsible for interfacing with victims and prosecutors. And this is a model that exists obviously in the civilian world. Many of you may have at some point served in that role, but that position is one that you will frequently hear from them on logistic issues. One of the challenging things is like getting on base. So I have every Victim Witness Liaison's number in my phone. I try to be as nice to them as I try to generally be nice, but I'm trying to be super nice to the Victim Witness Liaison because that's the individual who's going to assist with getting me on base and traveling your client. So it's either the Victim Witness Liaison or the prosecutor who is going to develop all of the travel arrangements for your client should they have to fly or travel in some way to the court-martial itself, which is something that the military pays for as part of the court-martial process. So having those good relationships with them helps to facilitate what is candidly one of the least legal but most important things to take care of when you're representing your client, which is to make sure that those logistical issues are handled and handled well in light of the trauma that comes with and the stress that comes with going to trial itself. And then lastly, our potential experts. So it is common in the military, more so in the Air Force than elsewhere, but even in other jurisdictions, for both sides to have forensic psychiatrists who are involved in the case, whose job it is to provide not services to your client, but expertise to the government, potentially on a consulting basis, potentially on a testifying basis. Most commonly comes up in alcohol or drug-induced assaults, where the question of memory is an issue, but they're not limited to that. So knowing who that is and interfacing with them so that you know each other is, I think, helpful because you're going to be sitting next to them during the court-martial process itself. So that's what I have for you on the military side. On the civilian, it's really just going to depend. I think the most important, Ruth may have mentioned this, but to me, the most important thing is for you to have a handle on what services your client is receiving, whether it's therapy services or other support services, so you have a sense of what's happening there in order to be able to ensure and protect those rights, because obviously there are going to be medical and therapy privileges and privacy issues that may attach there.
So much to learn and to get to know, no matter where the client is navigating. We want to take our final break now, and then we're going to come back and jump into a hypothetical, everyone. So we're going to share the hypothetical when we get back. But before we do that, we'll answer a few of the questions that are pending, and then wrap up with a real practice session together. So let's come back in 9 minutes. So it'll just be a 9-minute break. So at 20 till the hour or 40 after the hour, wherever you are currently. We will see you then. So let's grab our last little coffee break or whatever you need to get through. We'll see you in just a bit.
Welcome back. I think our break is now officially over. Before we get started again, we just wanted to go over a couple of the questions that came in during the last little bit. And Ruth has already answered one of them, but it was a really great question. So I just want to read it out and then also read Ruth's answer. And if there's anything anyone else wants to add, we can. But that question was, if you're discharged and still dealing with PSD or PTSD, how would this work for the victim with the military and lawyers and advocates? Would that still be something that's available to the victim? And so, Ruth, I can read your answer, or do you want to share what you had to say?
Well, what I said was that you can if somebody's been discharged, there are other things that they may need your help for. So in the military, it would depend on the branch of service. Like I know in the National Guard, if somebody has been sexually assaulted when they were in the National Guard, we will give them expanded legal assistance for things like being able to help them through what legal avenues that may be available. Usually if that happens, a lot of time has passed. So there may be things that they really, the VA claims particularly, and just being able to have it reflected in their record, their medical record when they were discharged in the medical evaluation board process, that just acknowledgement that they were assaulted. So there's more soft skill kind of issues that can be by exception. So yeah.
If I understand the question, so let me just throw out a few scenarios, right? If the individual victim was assaulted while active duty, they qualify for victims counsel. Their current status does not matter. If they're a military dependent, they qualify for victim services in the branch that they are a dependent. All right. It is civilians who are not DoD card carrying or military dependents who do not qualify for services. There are exceptions that can be granted, and occasionally that does happen. But the reality is, one of the reasons why we continue to do this work, why my firm and I continue to invest resources here, is that even where there has been where there exists representation, these victims counsel are overworked. They have too many cases. And they just, no matter how good they are, they just simply cannot devote the necessary attention to every single one of their clients. But you do get them if you are out of the service, if the assault occurred while you were on active duty.
Yes, and that's kind of the key if you were on active duty. But if you were not on active duty, you still may be, like I said, depending on the service, you still may be entitled to legal services.
Great. I think those are both really good.
And civilians are, sorry, Susie, civilians are entitled to certain advocacy services, even if they're not entitled to victims counsel. So there is certain victim advocacy services. I'm not an expert in that space, but it is common for, and this, I'll say this is for 120, this is for sexual assault cases, right? That's the covered offense. For domestic violence, it is not at all mandatory in most jurisdictions, and it doesn't cover sexual harassment or any other non-covered offenses. So we're talking only in terms of the provision of victims counsel by the military, we're talking about Article 120 sexual assault cases.
Well, domestic violence, they are entitled to, they became entitled to legal representation in NDA 2020, but each service treats it differently. Like I know the Army has the representation. It doesn't go to the Special Victims Council of Domestics. It goes to their legal assistance program. So yeah, each service is different.
Great. Okay, and then just one other question that came in, which is there any time where the victim advocates are not allowed to be with the survivor during a law enforcement or attorney interactions?
Never
Thinking
when
about confidentiality or privilege.
Not that I'm aware of. So there is in the 412 context and also in the 513 context, although not mandatory, courts will close the hearing. And so the only ones who are allowed to participate are the parties and the victim's counsel, and the victim advocate is not excluded. I was last week just at one of those hearings where the victim advocate was sitting next to the victim during that process. So in my experience, I cannot think of a circumstance in which a victim advocate would be excluded. They are commonly present, not always, but commonly present during initial interviews. It also depends on where the victim is and like the level of services at the institution in which they are reporting.
Great. Thank you. And thanks for everyone who put in those questions. Those are great.
Yeah, I'm loving the questions. Keep putting them in. It's fantastic. I'm going to go ahead and share screen again, everyone, but do not stop with the questions. Susie and I are keeping track of them, and we'll make sure that we have time for them as they come in. So we're going to turn to a case study now. What we're going to do is I'm first going to have the slide that's on there, then I'm going to put up a slide that has some level of facts, and then we'll come back to this slide again, just so everyone has the information. But this slide, I'll read out loud, tells you what generally we're going to cover in it without any details. So we're going to talk a little bit about an assault, the initial report, survivor referrals, investigation, defense subpoenas, the trial, victim impact statements, and then a little bit of the aftermath. So that's just so everyone has the landscape. Now I'm going to put up a slide that has a name for the case scenario and a little bit of the facts, but still we're not giving you a lot of the facts in the hopes that we don't cause any pain to folks with specific facts. But here are some of the details. Sandy is a civilian who went to a party on base, meaning on a military base, with her friends from high school who are now in the Marines. At the party, Sandy met and hung out with a Lance Corporal in the Marine Corps. Sandy drank, became intoxicated. Sandy wanted to leave, but her friends wanted to stay. The Lance Corporal said he would take care of her and took her to his room. She passed out. She woke up to being assaulted and passed out again. A few hours later, she woke again, left the room, and found her friends and left. Sandy has no experience with the military. When she told her friends, they said she should report the incident. She reports the incident to military police. The interview is a terrible experience, and Sandy did not feel believed. She knows she has photos on her phone from that night. Sandy contacts a local rape crisis center and is referred to you, a civilian attorney. So that's the setup for Ruth and Ryan to kind of share their expertise with us. As we are unpacking this again, feel free to put questions in the chat or in the Q&A, but I'm just going to start facilitating some Q&A myself to Ryan and Ruth. So the first question is, you are now involved in the case as the civilian attorney. What do you do, or what do you think about that first interview that has already happened that you were not involved with?
You tell them you didn't know what you were saying. No,
So I would not say that. So the first thing that you're going to want to do, so you're interfacing with your client, right? So you've gotten the case, right? So the first thing, of course, is that you're going to talk with your client and explain the process, right? You're going to walk through with them what your role is. You're going to identify and explain sort of what the next steps are in the process. You're going to make sure that you know who she has spoken to, like who is the military. When you say military police, right? Which I know we're using short form for this, but like, who was it, right? Because the military police is different than the military investigative units. Like the military piece are MPs, they have base access. They, you know, they don't do the types of investigations we're talking about in terms of, they don't do these types of interviews. So who exactly did she speak to? Does she have any information about that? Does she have a copy of the interview? Does she have any other materials that she was provided? And is there, to her knowledge, what's called it, we haven't talked about this, a military protective order in place. So a military protective order goes through the, it is, people say that it's like a civil protective order. It's really not. It is a non-judicial order that comes from the accused command that tells that individual what to do or not do. And it is not issued through a court. It is not enforceable in a court, but in the military, you do what you're told, or you could be violating a crime. So do you want to know if she has a copy of that or anything else that she has in terms of those issues? And of course, you're going to go through what you would do with all survivors in terms of safety planning and the like. I generally, in my first interviews, do not go through the facts of the case. Enough to be able to do my job, but not enough to be able to prepare my client for trial. So you're going to do those things. And then you're going to reach out. At this point, you don't know who the prosecutor is. You don't even know what the case status is. So you're going to reach out to the military investigative unit. You're going to introduce yourself as victims counsel, and you're going to get a case status report. Within the military, there are supposed to be, I think this is generally across branches, an individual who informs victims of the status of cases. That's not just the military. This is an actor that I forgot to describe. There is somebody who is supposed to inform the victim of the status of an investigation on a monthly basis, or at least periodically. That doesn't always happen. So you may wind up interfacing with someone like that as well. But you're basically trying to get, a handle on where they are procedurally. As a general rule, you want your client's statements as soon as possible. So you can ask for them. It is a rare circumstance in which a military investigative unit is going to turn over your client's statements. You're going to likely need to get them from trial counsel. So those would be the initial steps that you would take in the process as you're trying to assess what the case status is. You're not, in my opinion, and then I'll shut up and let Ruth talk. In my opinion, in this initial conversation with any military actor, it is not the best time to lay into them about how terrible they are at their jobs. So there are times for that, and there may be advocacy issues, but initially what I'm trying to do is to develop trust between myself and those military actors, because I'm going to get better access to information, and I'm going to be more likely to be able to advocate effectively for my client.
Ruth, you put some things in chat. I'd love to have you just share those.
Oh yeah. So it's what Ryan was saying is exactly what I had talked about previously. So the first thing is what was the status of your client? What was the status of the person who committed it? Where did it occur? And it looks like we don't know whether there was whether it was military police. So it looks like you still got a shot at the actual interview. And no, I really don't have anything to add to that, except for did want to mention about the case management groups they're actually mandated to have them every month. And it's a forum where and there's a list of people. I won't go into that, but it typically involves like the SARC, the victim advocate, or representative of the command to be able to determine what the status or give updates on the status of cases. And that can be a very valuable space when you're trying you're sitting in the room and you're able to say, well, this was done, but we've been waiting on this. And then people actually have to talk to each other face to face. It can be very interesting. So I think we're at the part where we've got the interview and on to what's next.
Yeah, and one thing I want to flag is for those of you who are civilians, something that both Ruth and Ryan have hit on is your client, and if you remember, Sandy has no military experience, and they just reported, and they're telling you it was military police. That might be the vocabulary they come to you with, which means it's your job to know who, because as Ryan pointed out, military police are just police doesn't mean the same thing in across the board. There's very specific titles. So I think that's really important. Ryan, one piece of clarification, just so everyone hears this really clearly, because you gave a really great nugget, and I don't want to try and paraphrase. What, from your perspective, is the difference between an MPO, military protective order, and the civilian protective order that people are so used to hearing about?
Sure.
What's the important distinction you were making?
Yeah, so a military protective order is not enforceable in a civilian court. It obviously can motivate the accused to avoid taking actions, right? That's the goal of it, because if they don't follow the military protective order, then the command can take punitive actions against them, and it can also be a crime. So the failure to follow the failure to follow orders. So that's what a military protective order does. What it doesn't do is provide the civilian mechanisms for enforcement of a civil protective order. So if your client is seeking a civil protective order, the military protective order may be a fact that is relevant to a consideration as to whether or not a court would impose a civil protective order, but it is not by itself enforceable. I still encourage all of my clients to have one. It's especially helpful if there has to be a law enforcement engagement and you're needing to demonstrate to law enforcement, your client needs to demonstrate to law enforcement that there's an active investigation and a case and the person should stay away, or there's some other safety consideration. So your client should ask for it and obtain it and carry it with them if they have significant safety concerns.
And I'll just add to that, if they do have a military protective order, civilian authorities can be notified that in the case there's a violation of that order off post. So I mean, that can be, if there's an emergency or something like that, that will be helpful.
Yeah,
that's great. Okay. Let's pivot, as Ruth was having us do, to what's this next moment. Well, Sandy also shared with you some information about that they think they have photos on their phone that might be relevant to the night and the incident. Ryan, you already hinted at this a while ago when you were talking to us, but what would you each be doing with Sandy around any the photos or any evidentiary moment?
Yeah, so there's a couple of considerations here. She's a civilian, so you don't have as many concerns about what's called collateral misconduct. You don't have collateral misconduct concerns, right? A lot of victims, when they come to report a crime, they might be underage drinking, for example, right? Or they may be something else that they're concerned of that might impact their military career that might be on their phone. You want to make sure you explore whether they have any of those concerns, specific concerns about what's on their phone beyond a general and understandable desire to protect their own privacy. Right? Are there those issues on the phone? So that's number one. Number two, for example, I've had clients who commit crimes. Like, that's bottom line is survivors also commit crimes. So is there anything like that you need to be aware of and you need to be worried about in terms of your client's electronic device? Then I want to look at what we're talking about, right? I want to see what it is that is on the phone, what the interactions are. And this is where I will get into the facts a bit, because I will want to make sure I understand what it is that she has on her phone and what it is we think could be helpful. And then here there potentially has already been an interview, right? So knowing what the law enforcement already has, it is common for military investigative units, when a phone is not provided, to take snapshots of what is on the phone itself. They will physically take a snapshot. So that is a mechanism for doing so. I also generally just like to print them out if I'm going to be then providing them to either law enforcement or trial counsel. So I'm gathering those relevant facts, and then I am providing them to the appropriate authority. Here, we don't know if there is a prosecutor, right? If there is a prosecutor in the case who's been involved, if the investigation has proceeded far enough along that there has been that consultation, then you're likely going to be providing that information either to the military investigative unit or to trial counsel, or both. It really depends. It's fact specific and varies depending upon the people who are in those positions in terms of what takes place. But you're going to want to gather those facts and be in a position to be able to provide them without agreeing to waive and provide their entire phone. There are limited I cannot think of a single circumstance where, as an initial matter, I would recommend turning over a phone or a computer, an entire phone or a computer.
if you had just said something other than that, Ruth or Ryan, we would have jumped in being like, no, no, no. We NCVLI definitely takes that position too. Well, so Ryan, you were both leading us to, so what about if there's a prosecutor in the mix? So let's say that it is with special trial counsel, or you think it is, but they're not communicating effectively with you. You're not sure what they're going to do with the case, right? There's this initial moment where they're deciding what to do. What are you as a lawyer doing in that space as you're trying to communicate with a special trial counsel?
Yeah, so you obviously you need to make contact, right? So it is a rare circumstance that I have where a special trial counsel just ignores you. They're generally not going to ignore you. They are busy, but they're not so busy that they're just going to be in court every single day. It is very possible though that there will be a delay because they are frequently in trial. So there will very well be those types of delays. So you want to afford maximum opportunity for your availability, like not give them just one date or one time. You have to recognize, well, you don't have to, but I suggest you recognize that their flexibility, they have to go where they're told, when they're told to go there. There's a lot of trainings, a lot of other obligations. So being flexible in your availability will help to assist that. And then my first conversation with the prosecutor is one in which I am trying to be very clear that I believe that a positive working relationship between the prosecutor and the victim is one of the primary missions and jobs that I have as victim counsel, right? It's not my only job, but facilitating trust between the prosecutor and the victim is in everyone's interest. It allows for the prosecutor to be engaged. It motivates the prosecutor because they are being respected and they are being treated with dignity and respect in the process. It helps the victim because the victim doesn't perceive the government as not caring. And no matter, you can't control necessarily the outcome of these cases, but you can certainly, to a limited extent, control the process itself. And so a positive experience with the government is one that is to the advantage of your client in terms of long-term recovery, in my view. So you want to build that trust with the prosecutor. And then after that, you want your client's statement. So whatever happened in that space, you want to have it. And the military is all over the place on whether or not pre-preferral, they will provide you with your client's statements. All right. So, but you want that. And so you should be asking for that. Right. And you can make arguments, even in the Army that generally doesn't provide statements pre-preferral. I get them all of the time. And I get them because I make meaningful arguments as to why I need them. Those are the facts of the case. How can I represent my client if I don't have the facts of the case? So you want to have that information as soon as possible. And I do not allow my clients to be re-interviewed unless I have all of their statements. I view that as not just a best practice, but it's borderline. Well, let me not get too dramatic. It is not a good idea for you to let a client of yours go in and speak to the government when you don't know what they've previously said. So you should demand to have those statements before you subject your client to any further interviews, absent extraordinary circumstances.
You know, we haven't mentioned, and I'm just going to go ahead. We've been talking investigations, and there's a organization, the Office of Complex Investigations in the National Guard, that's specially trained to do administrative investigations for sexual assaults, and now they're expanding to sexual harassment. So when those investigations are given, and mind you, they're for administrative purposes where a survivor has decided they don't want to participate in a criminal action, we do have the ability to get those statements in the investigations. It can be difficult, but we can get them. And I even had one that was, after that was done, the victim decided they wanted to go back and participate in a criminal trial because a civilian investigation was done so poorly that they were able to take that investigation that the Office of Complex Investigations used and then use that when they went forward to decide to prosecute. So I just wanted to sidebar on that because we haven't really mentioned the Office of Complex Investigations.
And this is why, like, this training is not the end of your learning curve, right?
Yeah,
this is everyone
exactly.
putting your toe in and starting to know a bit, and then know how to ask questions and know that it is okay to ask questions because there is so much So let's keep moving the case along. So we know what we want to do with that initial interview. We know what we want to do when there's some evidentiary moments. We know what we want to do to build relationships. And now we're in that real kind of pre-trial, pre-court martial moment where there is the discovery and happening. And so let's look at what are the most common things. And so I'm going to change the question up on you guys a little bit, or you all a little bit, excuse me. Like when a defense subpoena is coming for counseling records, or there's other discovery issues, what's the most common thing you're doing in that free phase to protect your client's rights and interests?
Yeah, so let's talk about discovery, right? We talked a little bit about this before. What does the discovery process look like? And when we talk about discovery, we're not talking about investigation. We're talking about what is the government going to provide to the defense? Because I helped with these slides, so it's not a defense subpoena. There is no such thing as a defense subpoena. Subpoenas are issued by the government. At the request of a defense, they can issue those, right? So you want to have early conversations with trial counsel to set the expectation that you would like to understand what the discovery is that they are seeking that impacts your client. Do not rely upon them to remember to tell you, okay? Reach out to them affirmatively. Ask to see the discovery requests themselves so that you can understand what is happening, right? And then talk with them at that stage, at the government stage. You're advocating before you ever get to court. You're making the arguments to the government as to why they should say no to things, right? Now, they may still not be able, when you're talking about a subpoena, there is a Military Rule of Evidence 703 provides, I believe, provides the victim with the right to be heard in court on these issues. I don't know how I lost this issue last week, but I lost it in a court last week. But the point is, even if you don't have it in court, you have it with the government very clearly, right? So making arguments and understanding their position as to relevance, as to necessity, right? Also taking steps to ensure that to the extent this discovery is potentially going to obtain privileged material, that you've taken the necessary steps to protect those privileges. So for example, and this is a best practice I would recommend. This isn't this particular scenario because it's not active duty, but I strongly recommend that you communicate with your clients outside of their military email addresses, maybe on logistics issues, but anything substantive should be on their personal email. When it isn't, what you wind up with is the ability of the government to access that information without a subpoena, and they can seek to obtain that information. So when that happens, and when there are communications that either the government or the court determine are relevant and necessary, they're going to pull that. That could very well be, I have a case that involves a word search that clearly was going to pull privileged communications. So in that circumstance, you want to make sure that you're taking the steps beforehand to seek and review those materials to withhold any privileged documents so that you don't have to claw something back after it's been produced. So those are the types of things that you would want to think through in that initial stage with the government. Then once you know the government's position, the standing in this space is a little confusing because victims do not have a direct right to dispute discovery that hasn't been issued. That hasn't, like where a subpoena has not been issued. They can move to quash after a subpoena issues, but arguing it beforehand, the standing arguments are a little obscure. So what you're going to do is you're going to use Article 6B, right, to dignity and privacy, right, to respect for and fairness with respect to dignity and privacy. You're going to use that as your hook for standing, and you're going to try to make the arguments with the court. It may be that the court shuts you down, so then that's why it's so important for you to be advocating with the government as well. And if it's not completely eliminating the subpoena, it's potentially narrowing its scope, right? So there's opportunities there for you to limit the harm to your client from the subpoenas themselves. If the information they're seeking is civilian information, there's also potentially important communications that you will need to make to those receiving units. So for example, it could be medical records or therapy records from the civilian side. If those are going to issue, you're likely going to be requested to execute a release. And if there are reasons to do this. I mean, it's very fact specific, and we don't have these facts here. There are reasons to execute a release in certain circumstances. but it's fairly limited. So if you don't want the records turned over, it's important for you to also engage with the receiving subpoena entity so that they understand that you do not want those records turned over. And then they will have their process where they require a court order. So that's what I have.
We are nearing the end of our time on the hypo, and so there's so much that we can unpack, and so I'm going to stop us on the details of the hypo unless you want to turn towards it, and have you each share one thought, and then we're going to turn to questions. One thought you have on that this is a good space for folks to come in, because there's so much knowledge you each have about how to represent, and it could seem daunting, but we need folks in this space. So on this hypo, thinking about it, like, what's your one big takeaway for folks on the line about get involved, you can do this work? Like, what would you say, Ryan, and then Ruth, and then Susie, I'll turn it to you for the next piece.
Yeah, so I'll start. I think it seems daunting because we're throwing a lot of information at you all at once, and this is sort of advanced. I didn't know any of this going in, okay? And even knowing nothing going in, my presence still mattered. And it is far better to have a lawyer in the room who's making arguments, even if they don't know every single process or procedure, than having the survivor go through that experience alone. So even if you're new, your ability to advocate, your ability to be effective as a lawyer is all you really need in order to make a difference.
And along those lines, I gave examples throughout as to things that you can do without necessarily having to go, or without necessarily being in the courtroom, that can still affect and lay out a path to the courtroom. So, and these are things that, you know, I gave the example of the SAFE kit, being able to do that, get the expert. It's creative lawyering. I mean, we're counselors, we're attorneys and counselors at law. And there are lots of ways to counsel your client when you're communicating with the players that are involved in the whole sphere, that they will listen to you where they may not listen to the victim, the survivor, because they are lower ranking, they're scared to say something. But when you're a lawyer, you have like almost instant credit. Well, you do. You've got a little bit of credibility. People make a lot of lawyers jokes, but you have instant credibility. People will listen to what you have to say. So that would be, I want more civilian attorneys. I really do. As a recently retired, retired from the military, who's done this work for a long time, I can't tell you how many times I wish I would have had a civilian lawyer to help.
I love that so much. Susie, I'm going to invite you on because also we're not going to let you do this work alone. So Susie, I'll turn it to you and I'll just be your scribe here advancing things.
Excellent. Thank you. So thank you to Meg, Ruth, and Ryan for getting us all the way here. And I think we've heard a lot today about sort of why and how civilian attorneys can make a difference. And I'm going to talk to you very quickly in these last few minutes about the resources and support that NCVLI can offer as you embark upon that work. And this gets to sort of what Meg started with, that you're not in this alone. And that we are here to support you. We have created all of these resources, and we're also here. We have all of these people here who want to help you. And so I'm just going to get started showing you what we do have. And I will say that we'll be sending out an email at once the training's over, that has a lot of these things linked in it, as well as some of the resources that we're talking about just included. So even though I'm going quickly, you will have access to them afterwards as well. So we'll start very quickly on this first slide, which is a screenshot of our NAVRA website. And NAVRA stands for the National Alliance of Victims' Rights Attorneys and Advocates. It's our NCVLI's Alliance of Attorneys and Advocates. And so part of the membership within this alliance is access to a bunch of different resources that are sort of highlighted here. And then, as Meg was doing, if we go to the next slide, we sort of feature each of them in turn. And so on the next slide, we have the pro bono portal, which is one of the things that we're most excited about and really want everyone who's here sort of interested in volunteering and doing work as a civilian attorney for victims to think about. I'm going to put into the chat the link to sign up. But the pro bono portal is a free portal where we're linking, attorneys interested in pro bono or low bono services with victims who are in need of those services. And one of our focuses is military connected victims in need of the services that we were talking about today, right? All the things that Ruth and Ryan were talking about, all those different opportunities for representation. So in order to have access to the portal, you do need to fill out this questionnaire, the link that I put in the chat, and that we'll send out again later. And for those of you who are here, not as attorneys, but as partners who work with victims in other ways, there are also opportunities to, post something on behalf of victims. If they're in need of an attorney, this is the place where you can, seek out that attorney by posting something. And in order to do that, you do need to be also enrolled in as a posting entity. And that link doesn't seem to be working right now, so we'll send that out in the email. But anyway, the idea is we're going to pair you attorneys with other people representing victims to get the victims who need the attorneys together. And this is going to be the best way to really connect victims with civilian attorneys who need them. So moving on to the next slide. This is another really exciting feature of NAVRA, and this is another free aspect of a NAVRA membership. And I put the QR code was on the last slide for how to, join NAVRA. And I can also put that here in the chat. But part of that membership is this Victims' Rights Attorney Toolkit, right? And has all these different pieces. And one of them, which you'll see, is, that they're going into the foundations of victims' rights law and practice, and especially for serving military-connected victims. So we have lots of resources that get to the pieces that Ruth was talking about today, really the communication aspect, the understanding culture part of it, the sort of background that you need to make those connections to sort of have the effective communication when you're representing a victim from a civilian standpoint. Maybe, this is your first time or you're just learning about these things. And along those lines, we also have sample military court filings in there for everyone to see, different templates. A lot of them have to do with some of the rules of evidence that Ryan was talking about earlier, Rule 412 and Rule 513. So they're really great resources for, again, anyone who's starting out, just to know that they're there and that they've been used before, that these are arguments that have been tried out. And so you're not starting from scratch. And we had a lot of great attorneys, including Ruth and Ryan, contribute to that brief bank. So we're excited about that. And then moving on to the next slide, just another highlight of NAVRA membership is a different tier of NAVRA membership, which is a paid membership, which you can learn more about on NAVRA's website. But this is a broader research database that has more filings, more military court filings. It has NCVLI's amicus briefs, legal memoranda, other things that will help attorneys as they're doing this work on behalf of victims. And then one of our really big parts of this project is the toolkit for advocating for military connected victims. And that's another collection of resources, videos, written resources that were created really with partially this group in mind, civilian attorneys and civilian advocates as well, to help everyone, expand how we're serving this victim population. And we started this toolkit under a previous grant that we had with Nova, and we've been expanding it under this grant. And one of the sections that I think I'm really excited about that we worked on this year is, again, goes to this communication, sort of what civilian attorneys, what civilian advocates need to know when they're working with military connected survivors, and as well as military connected personnel, right? And so it's these issues of language, culture, what the uniform means, what all of these other things that you just wouldn't know as a civilian. I learned a lot in the process of getting some of those resources created. So it's really great, and I really encourage everyone to enroll and to look through those resources. Enrollment in that is free, but you do have to sign up. And then I'm just flying through these, but we can go to the next one. This is just a screenshot of NCVLI's website, which has also lots of opportunities for more help and support. We can provide technical assistance and trainings. There are options there. We have a law library, which is full of stuff. There is a project page for this project on there that has a few of the resources that I've been talking about that are in the toolkits. And I had shared one earlier about collateral misconduct. Just, that was one of the things that came up, and that happens to be one of the tools that we shared outside of the toolkit. And that's also on our website. So there are just lots of things and lots of places. And I think, as Meg talked about earlier, there's a pretty big overlap between the civilian victims' rights work that we do and the military victims' rights work. So while a lot of the stuff in our law library isn't military specific and isn't specific to this project, the rights arguments and all of that is going to apply. And so I, again, would encourage everyone to look at those resources. And there's just so much out there. This just really goes to, there's so many things and so much support for you. So I really, you're not starting from scratch here. Lots of opportunities. And now, do we have any questions in the Q&A pending? I don't see any. Would anyone?
No, I think they have all been answered. Thank you for typing answers, Ruth and Ryan.
Gosh.
So that you had them. And thank you everyone for submitting questions. I'm going to give it just 1 second here to see if any come in, and I don't see any. So I think, thank you, Ruth. Thank you, Ryan. So much good information. And one of the things that we hinted at the beginning, but we'll share with you now, this recording will land up in the toolkit. So if there's something that you didn't catch or you want to take notes on differently, it will end up in the toolkit so that you'll have the capacity to access it there and kind of continue to learn. And again, our job is to help you do your job. So with that, I'm going to turn it back over to Nova.
Yes, thank you for such an amazing presentation. We deeply value our partnership with NCVLI and their knowledge and all of their support that they're able to provide us in being able to really advocate and support military connected survivors. So thank you for all of this information. As they stated, this recording will be available on the toolkit. We also have the NOVA's website and resources here as well, including a new website that will be launching and a link tree with some of these tools that they've referenced as well. But we've been able to partner again with NCVLI through that toolkit and provide very interactive tools and resources. So please use that to be able to register for the information, the webinars, the different tip sheets that can be very, very helpful in supporting military connected survivors.